Who is liable in real estate wire fraud cases? When home buyers or sellers lose funds in a fraudulent transaction, someone has to be held responsible. But is it the real estate professional, the bank, the consumer, or the fraudster?
In most civil cases, you have the two parties that were involved in the deal. And here, because of identity impersonation and social engineering, the main bad actor, the person that started this whole bad chain of reaction in events, is not here.
If you can't hold the fraudster responsible, then who is liable? Legal theories around real estate wire fraud are complex and opinions are constantly evolving, but precedent is starting to shape.
What I hope you'll take away is the idea that there are clear lines of liability that are being drawn in the courts, and there's something fuzzy as it relates to consumer protection.
So let's delve deeper into these two takeaways. What are the clear lines, and why are courts reevaluating responsibility for wire fraud?
What we can learn from these cases is the banks have almost full immunity, receiving banks in particular, for unauthorized transfers.
Banks are almost never held liable due to predefined regulations and guidelines for wire transfers. That leaves consumers and title companies holding the bag for any financial losses.
You send to the wrong account, you're going to be on the hook.
But is it fair to leave consumers on the hook when they didn't know the transaction was fraudulent? Whose job was it to protect them? Today, courts are working to determine how far they need to go with consumer protections.
What they're struggling with is you sit in a very important position by taking in other people's money with the responsibility of dispersing those funds out safely in a real estate transaction.
Because real estate professionals are considered the custodians of the funds, they are held to a higher standard of care. With the rise in wire fraud cases, courts are increasingly holding these individuals and firms responsible. And what about insurance carriers? Will they cover the losses? Professionals often discover in court that they're not actually covered for wire fraud. Recent cases have shown that courts will strictly interpret the policy. This reveals a lapse in coverage and makes firms unable to make a claim.
There's so many that sound like they cover wire fraud. Trust me, we insure more title agents, attorney agents, mortgage bankers than anybody. There's no coverage for this from the insurance perspective. You might think you do, but you don't. There's so many things that you need to do to get coverage that if you did those things, you wouldn't have had that loss.
These changes in the legal landscape mean that it's essential to have strategies for risk mitigation. You do not want to end up in court. Educating employees and consumers, having an incident response plan, and partnering with a wire fraud prevention company like Certified are all important parts of a risk mitigation plan. The best strategy is to have fraud protection and prevention procedures in place before disaster strikes. Download our Sued for Wire Fraud report to learn more.